So today's question, okay, is paper 3 law of contract, May June 2020, set 3. So as I've already given you all some time, okay, to read through this question yourself and also do a bit of draft yourself already. So now we'll go through together, and then after that I will actually put out my draft there as well, okay. And of course you're supposed to help me to build the draft, okay, together, and then after that we'll cross check it with the marking scheme to see how accurate is our answer lah. Okay. All right, so just going to go through first the question, yeah. Land Grab Holdings LGH owns a shopping mall in Barchester. In 2010, Menu Food MF leased one of the shops from them at an annual rent for £20,000 for a period of 15 years. By 2015, many of the shops in the mall had closed down due to an economic recession. Okay? MF asked LGH if it could reduce the annual rent to £10,000 to compensate for the loss. LGH agreed. Okay? By 2020, economic prospects for the area are better. This one is in a fictional world, again, not the world that we're living in. Okay? Right? Because we all know what happened in 2020. Okay? Barchester Council have relocated to offices nearby and transport links have improved. As a consequence, many shops are let again. LGH has informed MF that it intends to restore the annual rent of £20,000 for the remaining term of the lease, and it claimed back the arrears of £50,000 for the previous 5 years. Okay? Advise the parties of their rights and obligations, 25 marks. So before we actually even start to do the draft, okay, of course the first thing they need to find out is the parties. Okay, so who are the parties here? Okay, who's the one making the offer? Who's the one making the acceptance? Hello?
MF is the offerer, LGH is the offeree.
MF is the offerer and LGH is the offeree. Is it? Okay, lease one of the shops from them at an annual. No, actually MF, okay, is the offeree. Okay, LGH is the offerer because you see, okay, LGH owns the shopping mall. Okay, then MF lease one of the shops from them. Okay, right. So usually who is the boss lah? Right, the boss is the one that is not in this kind of situation, right? The boss is the one that is the offerer lah. So then, okay, okay, MF, okay, asked LGH if he could reduce the rent for £10,000 to compensate for this thing. So this is the second part. This is actually the second important thing. Okay, so he asked lah, okay, whether he can do so or not. Okay, so the reason why, okay, I say that Land Grab Holdings, okay, is the offerer and Menu Food, okay, MF is the offeree, is because this is the original contract. Okay, from the entire actually we should actually identify this thing first, okay. From the entire question itself, yeah, which chapter does it actually cover? Just a quick one.
Consideration.
All right, consideration, that's good. Okay, so that's why it's from this thing, okay, from this knowledge, okay, that consideration, you will know that, okay, in consideration usually consideration is for to make sure you need to have consideration in order for a contract to exist. Okay, but for this kind of situation, right, okay, we are actually talking more specifically about what topic in consideration.
Promissory estoppel.
Okay, but promissory estoppel is actually an even smaller subtopic. Okay, so promissory estoppel is actually from which bigger topic?
Is it existing contractual duty?
Yeah, existing contractual duties. Okay, all right. So that is why, okay, here we can assume that there's already a contract between Land Grab Holdings and Menu Food. Okay, right. And the terms of the contract is actually this thing here, right? Rent, okay, £20,000 for at least 15 years. Okay, then after that, okay, this is the second thing. Okay, the next thing, okay, that we should actually be concerned with. Okay, that is what like this one of y'all say, okay, promissory estoppel, right? Okay, so promissory estoppel, what's the principle behind promissory estoppel? Okay, never mind, it's okay. All right, so promissory estoppel is about a person, okay, when the one who makes the promise lah, okay, the one who make the promise, okay, to do something, or usually means to forego certain rights, okay, then the person cannot actually go back on his promise. Or in other words, okay, is stopped or prevented from going back on his promise, okay. And so LGH, okay, is the one, okay, who is making the promise here, okay. So when you come back to this part already, then suddenly it seems, okay, that MF, okay, is the offerer and LGH is the offeree. That's why just now, when I asked you, okay, who is the offerer, who is the offeree, okay, you say the other one. So I guess you straight away come to this part already. So it'll be good to actually go through step by step lah, okay, to actually identify, like I say, what chapter this is covering, okay, what particular part of the chapter is covering. Then only we get into the crux of it, which is this part here actually, okay. And of course, because the promisor, okay, can actually come from both sides, right? Both are actually promisors, okay, right? Promisor, promisees lah, actually, okay. And in this situation, okay, LGH, okay, is the promisor, all right, okay. All right, and then what happened after that is, yeah, officers are already much better, blah blah, whatever this whole thing here, okay. Then many shops are let again, okay, right. So it's like everything back to normal already, apparently in 2020, okay. And then, okay, LGH, okay, has informed MF they intend to restore the annual rent for the remaining term of the lease, and also to, more important thing is actually this thing here lah, claim back, correct or not, okay, right. This is the thing here, okay, that is actually the issue in regards to the promissory estoppel, okay. Okay, can you tell me the conditions, okay, for promissory estoppel? Just a very quick one before we start drafting. What are the conditions of promissory estoppel?
Pre-existing contractual relationship,
Okay, which is the first
a
one here, right?
promise,
A promise.
reliance,
Okay, and
and that's all right.
cannot create new rights and stuff like that lah. Okay, remember, okay, it's used as a shield, not as a sword. That is basically this thing here. Okay, right? Cannot go back on his
Okay,
promise lah. Okay, right? But the main one are
okay.
those that you actually mentioned just now. All right, okay, good. All right, now we can actually go into the actual draft itself already. So because you actually done your own draft already, so I would like you all to actually help me out lah. Okay, all right. So intro first lah. So intro as usual, okay. This one I help you all first, okay, right? Because this is from the top, from the part, okay, in the syllabus, okay, formation or contract, okay. So definitely you need to firstly start off by defining define contract, okay, just a very quick one. And also, okay, give a brief, okay, mention about the requirements for formation of contract, right? Okay, then the next thing what you all should be doing, come help me out a little bit.
Issue of the question.
All right, so highlight the issue of the question, which is about what, and also covering what particular chapter and all that, right? Okay, issue of the question, and also what the sorry, which chapter the question is covering, right? And here, of course, we know that it is about consideration, okay, right? Consideration, and of course, and more specifically on existing contractual duties and promissory estoppel, right? Okay, so these two things, okay, so we need to highlight. Okay, of course, the issue of the question is, of course, the facts lah, okay, what happened and all that, okay. In other words, okay, on the fact, okay, what happened and all that, okay, right. Then after that should be your thesis statement already, right? Okay, thesis statement. Okay, I know that y'all like don't really, some of y'all do, okay, sometimes y'all do, sometimes y'all don't, okay, depending, okay, but it's actually good to have the thesis statement there, so that you know, okay, where this question is, where this essay answer is actually going to, okay, right? So thesis statement, so here obviously is about trying to find out, okay, usually the thesis statement relates to the question itself. It's in the actual question which is here. This whole thing is actually the scenario. This is the actual question. Okay, so of course this statement we're supposed to address this thing, okay, which is we're supposed to advise their rights and obligations. So this question here, okay, it's good in the sense that it is very balanced. Okay, it's not like one-sided, you know, one-sided in the sense that it either asks you to advise LGH or MF. Okay, so because this question here is very how to say balanced, okay, so you can actually your conclusion doesn't really matter, I would say. Okay, you don't have to like die also help one person. Okay, that's what it means. Okay, usually if it asks you to advise only one person, okay, right, usually, okay, you have to try your best to help the person, but of course there should be some contrast here and there lah. Okay, but because this question very good asks you to advise both parties. Okay, usually you say something like that, advise both parties or discuss what's the better right or something like that. Okay, then it simply mean, okay, there is a free reign kind of question. Okay, right, so you can come up with whatever conclusion, lean on whatever side, doesn't really matter. Okay, but of course, okay, your T statement should actually address this thing lah. Okay, so of course here it will be something like this lah. Okay, in order find out who has okay, find out the rights and obligations of each party. Okay, we will have to here, of course, okay, because we know that, okay, it has something to do with consideration, contractual duties and all that already. We have to consider, okay, the validity of the uh, promise, okay, to forego the rent, okay, that was already reduced, right, something like that lah. Okay, right, then after that we go, I guess this is okay already for the intro. Okay, no problem there, right? Right, so now point one. Okay, so what do you think that we should be talking about now? Anybody?
Definition
Definition of what?
of
Definition.
consideration.
Okay, fine, we can go into consideration here already, it's fine. Okay, right. Okay, so the definition, define consideration. Okay, right, so I'm just gonna leave it as that lah. Okay, define consideration, just give me a quick one. Okay, how would you define consideration in your own words? Okay, fine, now consideration is basically, okay, something, okay, that must be I'm just using my own words and how I actually understand it lah. Okay, something that must be used, okay, in exchange for something else in the contract that has some economic value. Okay, even though, okay, it might be disproportionate. Okay, so this is just one way of defining it. Okay, there are many other ways of doing it. It doesn't really matter. Now, of course, this one thing you should know lah. Okay, the main case for definition for consideration, what is it?
The Dunlop and Selfridge.
All right, good. Dunlop versus Selfridge. All right, good. Okay, all right. So this definition, yeah, you all must actually have it in your the answer. Okay, because you say, of course, you say start off with definition first. Okay, okay, so fine, define consideration first. Okay, but of course, okay, the whole thing about I mean, this whole part about consideration, right? Okay, is actually like our bridging paragraph like that lah. Okay, right? Because we cannot go straight into talking about promissory estoppel or even existing contractual duties. Okay, because all the while, okay, in classes, I always emphasize, okay, that you actually need to start off somewhere first. You need to build your essay first, okay, to get to the core of the answer. All right, so consideration. Okay, so so then after this, okay, after the, well, this more or less the principle already lah, okay, of consideration. So after that, what should we do? Anybody, can I get it from the other person?
Describe the scenario, is it?
Or yes, something like that. Okay, basically now apply, okay, the principle regarding consideration into the scenario, right, by describing the scenario in more detail and then see whether there is any consideration at all. Okay, so obviously, okay, on the fact, right, okay, the original consideration was this thing here, right? Okay, right, so the parties have, okay, sorry, the consideration that both parties have exchanged with each other is £20,000 rent of 20,000 annual rent. Okay, I'm just gonna copy paste this whole thing. Okay, is the annual rent of £20,000 for a period of 15 years. All right. Okay, so that is the original consideration going on there. Okay. All right. Then of course here, okay. Next one, we're actually more or less done with this point already lah. Okay. Next one is, okay, we need to highlight that the issue is actually with the reduced rent. Okay, I think just this one should be fine already. Okay, reduced rent, with the reduced rent, with the reduced annual rent to £10,000, which, okay, LGH agreed to. Okay, and whether or not LGH can claim that amount back. Okay, since on the fact this is what he wanted to do. Correct or not? Okay, there's a typo there. Hold on. Okay, so this is what you want to do: claim back the arrears of £50,000 for the last 5 years. Okay, because this, I mean, the whole thing stopped at 2020 lah, right? And I see here £50,000 okay, so £10,000, okay, per year, okay, reduced to £10,000, originally £20,000, correct, okay? So 5 years, so £50,000, okay, for the last 5 years. So this is actually the most important thing here lah, that he actually wants to do, right? So that's why this is something that you should highlight at the end here. Okay, and the reason why I highlight this thing is because, okay, like I say lah, okay, this part is the bridging point, okay, from this part to the next part, okay, which definitely is about the crux of the answer already. Okay, all right, so point two. Okay, so point two, what should we be talking about now? What should we start off with?
Start applying the principle.
Applying the principle of what?
What I wrote is like I mentioned Williamson versus Ruffy, and then I just state that whether there's additional practical benefit for the
Okay,
other party.
all right, I think
Something like that.
okay, I think that's a bit too fast already. Okay, you should actually talk about this thing here first, existing contractor duties first. Okay, all right, as in because you're the Wins and Roffy, that one, right? Okay, is actually on what I call it, the goods and services. Okay, promissory estoppel is actually about contractual debts. Okay, right, to pay back debts, right? So Williams and Roffy actually not that relevant, but of course you can actually still point it out lah. Okay, but here of course, okay, the first thing that you should be talking about first is discuss the principle regarding existing duties and more, and of course more specifically existing contractual duties. Okay, because, okay, on the fact, okay, the issue, okay, concerns the contractual relationship between both parties, right? Okay, so of course you need to talk about existing duties, and of course existing contractual duties first. Okay, as you know, existing duty is when there's already an existing case. So the principle is this, okay? Okay, when there is an existing duty. Okay, let's talk about contractual duty more specifically better. Contractual duty, okay, between both parties, okay, then they cannot use whatever it is that they have, okay, promised each other, okay, to do as new consideration for something else, right? So what case tells you this? Okay, especially regarding contractual duty, what case tells you this? That when you already agree to do something already, okay, and then that's it, okay, you cannot actually use it as consideration for something else. What case is that?
Still and married.
All right, good. All right, good. Okay, still and married. Okay, and of course, usually still and married, okay, will have to be contrasted with
Hartley and Ponson
Hartley
B.
versus Ponsonby. All right, all right. And of course, again, this whole part here, right? Okay, you don't need to go through in too much detail. Okay, just very quickly, briefly, and then just tell the difference between the two. The reason why I say that is because this is prompt based in our question. Okay, and then this is not really the thing that we should really be focusing on yet. Okay, so no need to go through into detail, but just at least just mention and also give the legal principle, okay, between the two. That's all, more or less. Okay, right? So now, okay, what should we be doing here? Okay, after highlighting the principle, we should actually, okay, follow the steps lah, okay, like before. Okay, usually I'm not sure whether I mentioned this thing to you before or not, probably have. Okay, but in my other videos, usually this is what I mentioned, okay, that after defining the principle, okay, and then going through the principle a little bit, explaining it a bit, then you should actually be highlighting the facts, okay, like just now what one of you actually said, okay, highlight the facts, okay. So same thing here, okay. So on the fact, there already exists a contractual duty between the two, okay, of them, okay, regarding the amount that should be paid, right? So by right, okay, this LGH should be able to get the 50,000 pounds, okay, arrears, correct or not? Okay, then okay, you have this thing called what, but this thing regarding okay, but then okay, cases, okay, then cases like what just now one of you mentioned just now, Williams versus Roffey, okay, we Roffey have actually made some exceptions, okay, for this kind of situation. Okay, however, of course, you need to mention that Williams versus Roffey is actually about what? Contractual duties regarding goods and services. Okay, so here, therefore, which case is more relevant for this thing here? Williams or Roffey is not, okay, because it's about contractual duties. Now the other case, come tell me. I'm sure you've written it down somewhere.
Pinel's case.
Yes, okay, Pinel's case. Therefore, Pinel's case is more relevant, okay, here, as it concerns what? Contractor duties to pay debts. Okay, so if you compare these two, okay, Williams and Roffey and also Pinel's case, which one is actually more relevant for our the LGH and MF situation? Which one? The R or Pinel's case?
Pinel's.
All right, okay, all right. Pinel's case is more relevant here, okay, on the fact, because okay, it's about debts that has already been forgone, I would say, forgo, okay, fine, forgo, all right, okay. So that is why, okay, now, okay, right, so therefore now we need to consider, okay, if what do you call it, LGH, okay, as effectively waived, okay, his rights, okay, right? So Pinel's case principle, okay, can you give me the principle under Pinel's case? Yeah, I tell you what,
The
yep.
the debtor must do something extra.
The debtor must do something extra to satisfy the debt, correct? You must do something extra to actually satisfy the debt, okay, right? But okay, so yeah, let's do that. On the fact, okay, is there anything like that or not? Okay, the debtor, who is the debtor in this situation? The debtor is MF, right? Okay, so did MF actually do anything to like satisfy the debt, anything extra, okay, to satisfy the debt? Because usually, like in the Pinner's case, right, okay, something must be done, okay, like Tom, they must give like a bird or like pay early or whatever it is, okay. So here got or not? Did the debtor MF do anything extra or not to satisfy the debt? Yes or no?
No.
No, right? Okay, so no. So that is why we need to go on to discuss about promissory estoppel, okay, which is one, okay, I hope you all know this, one of the exception to Penal's case, right? Okay, then of course, okay, I guess we are more or less done here already, okay, right? Then the next one is your point 3 already, okay, where we here obviously, okay, to be talking about promissory estoppel already, okay. So what, okay, so of course, as usual, start off by defining, sorry, estoppel. Okay, so can anyone give me a definition of promissory estoppel? Just a quick one.
It will make a promise binding even when there's no consideration.
Okay, will make a promise binding even when there is no consideration. Okay, this is basically it lah. Okay, because okay, this is an equitable principle, right? Okay, that doesn't really look at the contract itself, but concerns itself with fairness. All right. Okay. So this one you need to go back to your the equitable remedy, that kind of situation, or equity already. Okay. Right. So it will make a promise binding even where there's no consideration, because this is an equitable principle that doesn't really look at the contract itself but concerns itself with fairness. Okay. Next thing, what should we be doing? Come. The other girl. Next one.
Discuss the case of high trees case.
Okay. Fine. Right. Discuss the case of high trees. Right, so high trees, okay, so high trees, it's similar, right, okay, which is similar to the facts of the scenario. So it would be good to now go through the facts of the case in detail, right? Okay, so I'm not going to go through with you all here, okay, in the class itself, okay, but again, I'm sure you all know what that is already, so you all should read by itself, okay, right? Okay, and so you can see, most of the time, the scenario in the question, okay, will be somewhat similar to a certain case, okay, certain major case that the question actually wants you to focus on. Okay, because if you remember high trees case is about the wartime thing, okay, right? Whereby during the war, okay, also about landlord and the tenant situation, which is similar to this thing, okay, because the boss or the landlord, okay, is this LGH and the tenant is actually MF, right? So no, in the high trees case, they use the war situation, okay, right? And during the war situation, try to keep one of the tenants, and then the landlord say, okay, we reduce the rent, okay, right? And then after that, when the war's over already, okay, want to go back to the original rent, okay, which is similar to this thing here, okay. Just this one is about some economic problem, economic recession, okay, right, between 2015 to 2020. Okay, then the difference between this scenario here and high trees case is that in high trees case, the landlord didn't actually try to claim back the arrears, okay, during the time where the rent was lessened, okay. But then here, okay, it's about it. But then in high trees case, this issue was actually discussed, okay. So here, of course, when you talk about high trees, okay, the principle, okay, that is relevant here should actually be the orbiter dicta one, okay. So yeah, discuss high trees, which is similar to the fact scenario. So it will be good to now go through facts in detail and try to make a distinction between high trees and the scenario. All right. Okay, so next thing, what should we be doing? Okay, because now this one we just go through the facts of this case only, okay, high trees case only. So next one, what should we be doing?
The conditions to
All
rely
right,
on
good.
promissory estoppel.
All right, good. Okay, go through the conditions for promissory estoppel to work. And just now, as you mentioned just now, can you go through again just very fast? I think it was you just now mentioning it. Okay, what's the first one?
A pre-existing contractual relationship.
Existing contractual relationship. Okay, next one.
A promise,
A promise, okay, to forego rights. Okay, next one.
reliance,
Reliance by the other party. And lastly, this will help you, okay, inequitable, okay, uh okay, inequitable to go back on the promise. Okay, I've forgotten what exactly was it already, but it's something like this. It's either it must be equitable to do so, okay, right, to rely on for this whole thing to happen, or that is inequitable for the party to make the promise, okay, to go back on the promise. So it's something like this lah, okay, right? Okay, so go through all these things, okay, and then if they are okay, okay, and if there any cases in between, okay, which can be highlighted, okay, to emphasize on the principle of the condition, okay, then you can opt to just mention it without going through in too much detail, right? Okay, so something like that. So now, of course, the next one, okay, next one is of course applying it to the facts already, all right? So on the facts, okay, do you think that all these things have been satisfied or not?
I think no.
No, why?
The last one,
The last one, inequitable to go back. Why is it inequitable to go back? I think maybe you misunderstand this whole thing already. Why you just tell me first, why is it inequitable to go back on a promise? Mean to say that it is okay to go back on a promise, I think you misunderstand this thing already, okay? When I say inequitable to go back on a promise, okay, to say that it is not right or that it is wrong to go back on a promise. You understand that or not? Okay, I hope you understand that, okay, because I think you misunderstood this thing, because the way I write it maybe is different from in your book there, but it means more or less the same thing, okay. That, okay, if I'm looking at my book now, okay, I'm just looking at my book now just to confirm, okay, right, what is the actual words that it use, okay, even better. uh, okay, it just says that inequitable to enforce strict legal rights. Okay, so basically also it means that it is inequitable to go back on the promise lah. Okay, that you shouldn't actually, okay, now turn around and then say that you don't want to keep your promise. Okay, so in this situation, do you think that it is equitable or inequitable for LGH, okay, to go back on its promise and then now, okay, to claim the £50,000? Tell the same girl, what do you think now? Do you think that it is right or wrong for him to actually go back on his promise and then claim the 50,000 pounds? That's the question.
Wrong.
Wrong. So that's why, okay, it is inequitable. Okay, you understand that? You understand this thing or not?
Understood.
Understood already, yeah. Okay, so I think you misunderstand this last part here. So basically, okay, the whole thing is actually satisfied already. Okay, because you apply into the facts, definitely there's a pre-existing contractual relationship, right? Because there are landlord tenant contractual relationship going on. Okay, a promise to forego rights, okay, which the landlord has, okay, by reducing it to 10,000 pounds, okay, per year, and then the other party relied on it as well. I mean, this one here is a bit I'm not too sure lah, okay, unsure, because uh, because here it just says this, okay, by 2015 many of the shops in the mall had closed down due to the economic recession, okay, MF asked reduce rent. So we're not sure, okay, whether or not there's any reliance going on, but then we can assume there is, because I mean it's not so clear as the high trees case lah. So here we can actually bring up high trees case, okay, to actually emphasize on this thing here, saying that, okay, that the only reason why you are staying, okay, is because of the low rent. Okay, so there's definitely reliance going on here. Okay, and then this part here, which I've already explained already. Okay, applying it to the facts, okay, definitely contractual relationship exists. Okay, all right, because landlord and tenant, the same thing. This is also tenant. Okay, relationship. Okay, then the next one, LGH, okay, has promised, okay, or agreed to lower down rents, okay, and then after that, Reliance, okay, we are not sure whether there's actual reliance or not, but similar to high trees case, we can assume that there is, okay, actual reliance. Okay, all right, so this one here you can actually give your own reasons lah, like, right, everybody leaving already, why shouldn't I be leaving? Okay, I don't want to make a loss or something like that. Okay, so that kind of situation, okay, you just give your own thing lah. Okay, and then, okay, the lastly, okay, definitely inequitable or unfair for LGH to go back on the promise and try to claim back the 50,000 pounds, okay, right, that was waived during that economic recession years. Okay, right, or period, doesn't matter. Okay, all right, so I guess it's more or less done here already, but do you have anything to add or any question or not so far? Because I think we are done already. Okay, but we have to look at the marking scheme also lah, to see how accurate the answer is and all that. Okay, so far, okay, I hope that you all been paying attention all the way. Okay, so got any question or not, any problem or not before I move on? Anything that, okay, you look at your own thing and then look at mine now, did I miss anything or not? Important thing.
Teacher, in the beginning of the question, do I have to mention like both parties are offerer, both parties are offering?
No, it's only one offeree only. In the beginning, I mean, actually, there is, okay lah, okay, fine lah. The thing that you need to mention, but if you're talking about specifically offeree, okay, will be this part here lah. Okay, which is concerning the new contract. So here, okay, MF is the offerer, LGH is the offeree, something like that. Okay, because we are still talking about consideration here. It's just that it's about the extra consideration thing. Okay, so it's like a new contract. So yes, okay, there's this offeree thing still going on. So yes, okay, you should actually be mentioning it. Okay, Ken?
Okay, thank you, teacher.
Okay, all right. Any other question? The other girl, any other question?
Can I also argue from like MH side?
Okay, how?
I don't know. I mean, I'm just asking.
What do you mean argue from MH side? Because here we are actually arguing from MH side already. At the end of the day, okay, MH will actually be able to win the case. Okay, that he is the one that has the rights to keep the 50,000 pounds. Do you understand that?
Okay.
Okay. So we are actually arguing for MH side, okay, not MF side, okay, not LGH. Understand? And because the question asks us to advise both parties, okay, so we can lean either way, lah, doesn't matter, okay. And here, very obvious. I mean, when I look at it here, actually this part here, lah, okay, if you understand how penal's case works, right, alone, okay, sorry, if you understand how promissory estoppel case works, okay, alone, okay, without going through the hassle of what consideration, the existing contractual duty lah, penals case lah, right? You should go into promissory estoppel itself and you understand how promissory estoppel works, okay? As a whole, okay, you should be able to get a conclusion already that definitely this thing is bad. Because after all, okay, there's nothing else, okay, within the facts of the case which tells you otherwise. Because like for example, okay, what would actually make it inequitable, where is it now? Okay, what would actually make it equitable? Okay, equitable. Okay, right. To go back on a promise. Okay, is like in your book there. Okay, there's one case, right? D and C builders. Do you remember that? Okay, right. So D and C builders. Okay, what are those who come to equity must come with clean hands. That kind of situation. So in this case here, it's very clean. Okay, don't have any of that kind of element at all. Okay, which will make it equitable. Okay, for LGH. Okay, to claim back the 50,000 pounds. Okay, so obviously the principle or the conditions, okay, under the promissory estoppel, okay, is very easily satisfied. Do you understand that, all of you?
Teacher, but LGH can also rely on the penal's case or
What previous case? Pinot's case. Okay,
yeah,
that's
penal's
the
case.
thing. That's the thing. Okay, all right. Because okay, you want to argue both sides, like, okay, fine, okay, we need to say that you want to also use the penals case, okay, but questions like this, okay, but later we look at the marking schemes, okay, but questions like this, okay, it makes it very obvious already, okay, that they're actually wanting you to discuss about the promissory estoppel more than the penals case. But okay lah, fine, because the question asks you to advise both parties, you can actually talk about penals case also, okay, emphasize more on it, but then okay, you cannot actually forego promissory estoppel totally. Understand? I mean to say that both promissory estoppel and also penal's case must be discussed. So like if I would look back at this thing, right? Okay, this thing here. So here's the part where I'm actually talking about penal's case. Okay, so here you should maybe like open up another point. Okay, right, to talk about penal's case, and then after that talk about it in much more detail. Okay, why like this, why like that. Okay, and then however, okay, we may also be able to talk about promissory estoppel because the question asks us to advise both parties. You understand that or not? Okay, so mean to say that in between my point 2 and point 3, okay, there's probably another point here, somewhere here, okay, where you're actually talking more about penal's case, okay, and then after that your conclusion will be okay, depending on what the court actually would where the court would actually go, okay, right, either party will win the case, okay, depending on whether the court will actually focus on penal's case or promissory estoppel. Okay, so this is addressing your question, okay, but later we look at the marking scheme and then see whether or not, okay, we can actually do this, okay, because if we can actually do this and then you do both, okay, discuss both penal case and also promissory estoppel at the same time, okay, give it both the same attention, okay, then definitely you will be able to get a lot of marks for it. Okay, all right, does this address your question?
Yes.
All right, good. Okay, tell you what, there's no other question, okay, right, okay, don't want to waste too much time, so we now look at the marking scheme. Don't worry, I'll be sending this thing to you all later, okay. All right, so this is the marking scheme. Let me look at it easier like that. Okay, all right, so very quickly, okay, because this is a 2020 paper, okay, the marking seem to be much more in detail already compared to like a few years ago, right? Maybe people must have complained or whatever, I don't know. Right. Candidates should identify consideration as the issue, and in particular, the common law rules of part payment of debt and equitable doctrine of promissory estoppel. So you can see here, okay, this is the thing which is in our introduction already. Just that identified. That's why I say identified, right, in the introduction itself, which I think we did, right? Okay. There here, covering consideration, more specifically contractual duties and also promissory estoppel, right? So this is accurate already. Right, the next one, the common law takes the view that part payment of debt does not discharge the debt even if the creditor agrees to forego part or all of the outstanding amount. This is because no consideration is given by the debtor for the creditor's promise to forego part payment. Okay, so penal's case, right? Part payment, all right? Part payment of debt. So this one here, the first rate go into this thing already lah. Okay, but of course, like I say, this whole thing here, right, you should actually be discussing, especially this thing regarding consideration. Okay, this whole thing here, I would say, is actually talking about this thing here. All right, okay, the introduction itself and a little bit on consideration. Then only we go into part payment. But of course, before going to part payment, okay, it will be good to talk about existing duties first, and of course more specifically contractual duties. Okay, then only you go into the penals case. Okay, right. Okay, then okay, candidates should recognize that the rigid application of the common law principle can prove rather harsh in certain circumstances, and explain that the rule has been mitigated by the exceptions in Pinel's case, and more significantly, the equitable doctrine of promissory estoppel. So, as you can see here, it wants you to actually talk about, okay, not just Pinel's case, but also promissory estoppel, which we did. Okay, right? Next one, the doctrine as expounded by Lord Denning in Central London Property Trust, okay, High Trees case, okay, must then be addressed, and the condition on which the application rests explored, okay, meaning to say that, okay, you need to go through the facts of the case in High Trees, which we did, and also the condition, which is this thing here, pre-existing, okay, promise to forego strict rights, reliance, and also there's here inequitable, okay, to enforce legal rights, okay, and also this part here which we didn't put, but yeah, we should actually put this thing also lah. So I guess this is one thing that we missed, although this one I think I did mention it just now earlier, but when we were discussing this part with this part at time, okay, we forgot to put it. All right, so one thing is missing, okay, but I think it is also satisfied lah, no worries lah. Okay, this thing here, okay, so please take note of it, okay, which we missed out. Okay, used as a defense, not as an action, not as a cause of action. In other words, used as a shield and not as a sword. Okay, right, so yeah, so here they gave you all these cases, should at least mention them, right? And then remember here DNC builders, okay, right. Right, next one. Candidates should then apply this principle to the scenario presented. So MF is contracted to pay an amount, this amount of money for a period of 15 years. Clearly, they have not done this, and therefore, under the common law principles, okay, of part payment of debt, okay, LGH can insist on full payment of outstanding owed. Okay, so this is the original thing. Okay, right. The apparent harshness of this outcome can, however, be mitigated if Food Menu could invoke the doctrine of promissory estoppel. So therefore, straight go into promissory estoppel, or therefore don't even want to talk about Pinel's case, because Pinel's case, like I say lah, okay, it doesn't actually apply at all, because there's nothing extra that was given. Okay, so if you were to talk about in the MF side, okay, we straight go into promissory estoppel. Okay, don't talk too much about Pinel's case, all right? Okay, but then like I said just now, if you want to talk about Pinel's case, then it is actually on LGH argument, but later on we'll see whether they actually talk about that or not. Okay. Okay, next one. Candidates should consider whether all the conditions are present for the doctrine to be deemed applicable, and therefore prevent LGH from going back on its word to accept reduced annual rent for the duration of rescission. Okay. Okay, then so this is basically my side of the argument. Okay, arguing for MF. Okay, finally, Kenneth should argue LGH intention to restore the annual rent payment of £20,000 for the final 5 years of the lease is permissible given the circumstances which led to the promise to reduce rent, no longer continues as all the premises are kept are let and economic environment has improved. Okay, so this is part where we missed out. Okay, where not that important. Okay, but I guess this one is your the extra credit point now. Okay, which will be given. Okay, whereby you say that okay that LGH okay cannot claim the £50,000 but can restore the rent okay back to £20,000 after 2020. Okay, so that's what it means. Okay, and then general responses based purely on factual recall received. Okay, nothing much here lah. Okay, right. So apparently he didn't say anything about Pinel's case, and here apparently he's just citing one fella only lah, which is the MF. Okay, but I would say that it is okay, even though the marking scheme here doesn't actually say it. Okay, because it doesn't say that you have to die also like help one person only, okay, or the other person, okay, right? So even if you lean towards LGH side, okay, you must at least also talk about promissory estoppel. And the reason why you must talk about promissory estoppel is mainly because of this thing here. This is actually the giveaway point, I feel. This is a giveaway point, right? Very obvious, okay, trying to point out to you, okay, that look, we want you to talk about promissory estoppel. So even if you want to talk about Pinel's case and emphasize a little bit on it, okay, on the side of LGH, you must still emphasize on this thing as well. Then only you'll be able to get the full marks. Otherwise, if say for example the whole thing you talk about the Pinel's case, okay, you focus on that only, and you leave out or you talk very little about the promissory estoppel, okay, and you don't even highlight this thing at all, okay, then definitely, okay, you won't get a lot of marks already. Do you understand that? Two of you?
Yes, teacher, LGH cannot rely on Pinel's case also because it doesn't provide any extra element.
Yeah, that's why I didn't provide any extra element at all, right? So that's why you can see I didn't really bother lah. Okay, all right. That's why I put this thing here. I remember this thing. Okay, there's nothing like that. Okay, all right. There's nothing. Okay, there's nothing. No extra element given at all. So that's why we go straight again next into promissory estoppel. Okay, so I mean you can like spend a bit more time here, okay, to consider a little bit more, but that's about it. Okay, the main thing is still here. Okay, because the date giveaway is actually this thing here. Okay, both of you, right? The other girl got any problem or not?
No, it's fine.
It's fine, okay. Right, tell you what, if it's fine, okay, then I think we can end this recording session already.